The White House is about to require federal workers to get their COVID-19 vaccine or to get tested on a regular basis. A CBS source says the administration is finalizing the rules, but the president will make the announcement tomorrow. Meanwhile, the Justice Department has released an opinion on vaccine mandates that could affect people who are waiting for the CDC to fully authorize the current COVID-19 shots. So for more on this, I want to bring in CBS News legal contributor Rebecca Roiphe. Rebecca, so break this down for our viewers. What is your understanding of what is going to happen in the next couple of days when it comes to federal workers?
So the background here is a 1905 Supreme Court precedent that says that states can require vaccines and enforce compulsory vaccine laws. What's different here is that these vaccines, the coronavirus vaccines, have been approved only on a emergency use basis. And as a result, there have been these challenges to requirements, including this requirement that you just mentioned. And the question is whether the federal government or states can require, or private entities can require employees to, or students or whoever, people who are participating in their business to get these vaccines. And so this opinion from the Department of Justice is, it's not binding on courts, but it is a statement about the executive branch, the president's view of the law here. And he has consulted with Department of Justice lawyers, and they have come up to the conclusion that the federal law does not prohibit this kind of requirement. So these will go forward, and there will certainly be challenges. This isn't the end of the story, but it's significant development.
So we're calling it a mandate, but there is an option. You don't have to get the vaccine, but you're going to have to undergo, this regular testing. Unlike the Veterans Affairs Department, which is mandating that frontline healthcare workers get the vaccine or they will be terminated. I'm wondering about the legality of that and whether or not an employee who doesn't want the vaccine has any grounds to appeal and keep their job.
Well, certainly there are grounds to appeal. The question of whether those grounds will be successful. And in my opinion, the better legal argument here is no. That in fact, what the federal law says is not that that this emergency use justification has to be optional, but rather that there has to be an informed consent. So in other words, people have to be informed of their right to refuse the vaccine. But of course, there's a huge incentive to agree to it, because otherwise you're going to lose your job. But that doesn't mean you're being forced to take the vaccine. You're being pressured significantly because your employment is at stake. And those who are challenging these requirements are suggesting that it's tantamount to forcing you to get this vaccine, and that the law implicitly bans that kind of coercion. But there is, if you read the law as the Department of Justice opinion does, it really is a stretch, because what the law really has to do with is just, with these kind of emergency use authorization vaccines, there need to be certain kinds of disclosures. And one of those disclosures is your right to refuse. Of course, these individuals still have that right to refuse, even though they're being significantly pressured to give up that right. So to me, the better legal argument here is the one that the Department of Justice takes, but that doesn't mean there aren't avenues still open to challenge these requirements, because the Department of Justice opinion is not, it's binding on the federal government, but it isn't binding on, on the executive branch, but it isn't binding on courts. So courts could come to a conclusion completely at odds with the one that the Department of Justice reached.
So COVID-19 vaccines, Rebecca, aren't available to people younger than 12, but a lot of students are still vulnerable. Schools usually require a student's vaccination record when they enroll. So are schools going to be held to a different standard than businesses?
So, there's a question about whether, schools might be held to a different standard. I don't think so. I mean, there's, of course, a difference, again, also between a publicly owned, university versus a private school. And a private school, has, a greater degree of freedom in terms of what it does and what it chooses to do. But, certainly they have to be rational. So these requirements have to be rational, related to public health. And that's a very low bar. So there's a lot of deference to states to decide what is in the best interest for the public health of their students, of their citizens. And so there's a great deal of leeway here in determining how to deal with these things. There are some restrictions, and certainly federal disability and state disability and civil rights laws put limitations on this. So you will definitely see that most of these requirements will have exemptions, the right to have an exemption from the vaccine requirement if you have a religious objection or a medical reason why you don't want to get that vaccine. So those certainly are limitations, but beyond that, the law really does give a huge amount of discretion here for private employers and state actors to act in the public interest. They're called police powers. So the states have these police powers to preserve public health and can do a great deal.
So there have been a number of court actions across the country in regards to mandates like this. I'm going to run through a few of them. Federal judges in Texas and Indiana recently ruled in favor of vaccine requirements. A federal court in Texas dismissed a lawsuit last month brought on by hospital workers who were required to get the vaccine or they would lose their jobs. And a federal court in Indiana ruled that Indiana University could in fact require students and staff to be vaccinated. What sort of precedent do you see sort of being set here? And could you see these cases working their way up to the Supreme Court?
It's possible. I don't think this is actually a very difficult area of law. And sometimes when things are not complicated and confusing, the Supreme Court decides not to take a pass because there isn't really an issue of law that needs to be resolved. But, we have to wait it out because if there is a disagreement among the lower courts, it is entirely possible that the Supreme Court would take this up, especially since, as I said, this precedent that we're looking at is from 1905. So that really is quite a long time ago. It really is settled precedent, but it is possible that the Supreme Court could want to look at that again. In terms of the interpretation of the federal statute, that seems a less interesting issue to me because, as I said before, it's a real stretch to read the Food, Drug, and Cosmetic Act to ban these kinds of requirements. All that act does is say when there's an emergency use authorization, there needs to be certain kinds of disclosures. And for the most part, states and the federal government are complying with those disclosure requirements. So it's hard to see how a successful challenge could go forward, but that doesn't mean it's impossible. And I think what's far more likely is that once these vaccines get approved on a permanent basis, you might see an attempt to challenge the underlying notion that comes from that 1905 precedent that states have this broad power to interfere to a certain degree with people's liberty in order to promote public health. Again, that seems like a stretch to me too. This is long held. It is consistent with a number of other statements that the Supreme Court has made. So it seems extremely unlikely that the court would reverse that precedent, but it's not, it's not out of the realm of possibility.
Mm-hmm.
All right, Rebecca Roiphe, always great to talk to you. Thank you very much.
Thanks, Vlad.